Hi, and welcome to the 6th episode of my vlog, Personal Injury Lawyer Tips. My name is Andrew Lee Rudder. I'm a personal injury lawyer specializing in catastrophic impairment law. I'm also a published author of the LexisNexis book called Catastrophic Impairment Law in Canada, a director at Head Injury Rehabilitation Ontario, and a founder and owner of my law firm, RudderLawGroup. In this vlog, I'll be discussing the legal implications following a situation where in a collision between two drivers, the evidence shows that one or both drivers are negligent, but the trial judge is unable to distinguish between them. So this situation occurred in an older 1954 case entitled Lehman and Rhea, where a collision occurred on the south edge of the crest of a blind knoll on a straight road between the defendant and the plaintiff. The plaintiff driver, who had two passengers in the vehicle, testified at trial that the defendant crossed into his lane, realized too late that she was in the wrong lane, and then crashed into the plaintiff's vehicle as she tried to veer back into her own lane. The defendant testified that it was the plaintiff who crossed into her lane and crashed into her vehicle as he tried to veer back into his own lane. The trial judge, the Honorable Justice Harrison, said in this old 1954 case the following, quote, "My guess is that both cars are proceeding over a knoll in the center of the highway, and neither driver saw the other in time to completely avoid a collision. But after considerable thought, I'm unable to reach the necessary degree of certainty and conclusion as to how the accident happened or who was at fault. Accordingly, I must hold that neither party has established his case, and therefore, the claim and the counterclaim are both dismissed." End quote. Therefore, since the trial judge wasn't able to draw an inference of negligence on the part of both of the parties from the facts and the lack of either direct or circumstantial evidence, he dismissed both the claim from the plaintiff and the counterclaim from the defendant. Now, of course, the trial judge's decision was appealed, and the Court of Appeal for Ontario overturned the decision by equally apportioning the responsibility on both the plaintiff and the defendant, and thereby ruling that both parties were to be held liable to an equal degree. As such, the appeal was allowed, which saw judgments entered for both parties, whereby they both received 50% of their damages and 50% of their costs of trial. The Honorable Justice Bridges stated the following, quote, "I concur in the judgment of Justice Harrison. It is my opinion that where there has been a collision between two motor vehicles under such circumstances, that there must have been negligence on the part of one or both drivers, and the court is unable to distinguish between such drivers as to liability. Both drivers should be found equally at fault." End quote. As such, Lehman and Rhea came to be known as standing for the proposition that where the evidence shows that one of two drivers was negligent and the court is unable to distinguish between them, then both should be equally at fault. So this idea that a party can be found to be negligent in the absence of inferring it from facts, and in the absence of inferring negligence from either circumstantial or direct evidence, smelled of the legal doctrine that had plagued our courts for over a century. The doctrine I'm referring to, of course, is normally known as res ipsa loquitur, which translates from Latin to mean the thing speaks for itself. If you want to learn more about the legal doctrine normally known as res ipsa loquitur, then please visit my website and read my blog entitled The Modern Application of Res ipsa loquitur. The reason why this legal doctrine has created so many problems in our Canadian jurisprudence until it was finally laid to rest by the Supreme Court of Canada is because it flies in the face of how a plaintiff proves his or her tort lawsuit. Typically, if you sustain injuries and impairments for which you want to commence a tort lawsuit to claim compensatory damages, the burden of introducing affirmative proof of negligence is on you to marshal the supportive evidence and facts from which an inference of negligence could be drawn. However, negligence isn't automatically inferred on both parties claiming negligence if the court is unable to distinguish between the evidence submitted by both parties, claiming the other party was liable for the cause of the motor vehicle accident. So the Supreme Court of Canada overruled the Lehman and Rhea proposition in 1955 in a case entitled Wada and Halliburton Oil Well Cementing Company Limited. In this case, two drivers in trucks were driving in the opposite direction, and as they were about to pass one another, the rear of their respective trucks collided. The only two witnesses were the two drivers, so naturally their evidence and testimonies were conflicting. Like Lehman and Rhea, the trial judge was unable to make a finding of negligence against either driver. So since neither side had proved its case, he dismissed both the claim from the plaintiff and the counterclaim from the defendant. The judgment of the trial judge was upheld by the Saskatchewan Court of Appeal and then later by the Supreme Court of Canada. In upholding the decision, the Supreme Court of Canada overruled the proposition established by the Court of Appeal for Ontario's ruling in Lehman and Rhea, namely that where the evidence shows that one of two drivers was negligent and the court is unable to distinguish between them, then both should be equally at fault. As follows, quote, "The case of Lehman and Rhea was cited as an authority for that proposition. If that case really has that meaning, as it seems to have, I respectfully think that it should be overruled, as I am not aware of any principle that may justify a court of justice in a case like the one at bar to hold a person liable in damages, unless negligence is established. As it was said by Justice Jenkins in Brand-Palmer, there is no doubt that a judge is entitled in an action for damages for personal injury occasioned by the negligent driving of the defendant to reject the plaintiff's case, if in the view of the judge, the evidence does not suffice to make out that case. The onus is on the plaintiff. The same, of course, applies where there is a counterclaim. The onus is on the defendant to make out the counterclaim," end quote. Therefore, as the Supreme Court of Canada overruled the aforementioned proposition, it also reconciled the Court of Appeal for Ontario's ruling in Lehman and Rhea by distinguishing it from its case. It did so by showing that the evidence in Lehman and Rhea disclosed a collision from which a judge could infer that there was negligence on both drivers. The Supreme Court of Canada also confirmed that in a situation where it is initially unclear who caused the motor vehicle accident, the burden of proof still remains with the parties claiming negligence, the plaintiff in the claim and the defendant in the counterclaim. They introduce either direct or circumstantial evidence, which can constitute a reasonable evidentiary basis for establishing the negligence on the part of the other driver. If, however, the party claiming negligence cannot introduce either direct or circumstantial evidence to support an inference that the other driver was negligent, so liability cannot be found on the basis that the other driver was negligent, then and only then can a judge dismiss the claim. So, the Supreme Court of Canada set the record straight in a case where it isn't obvious who caused the accident. Before a judge can dismiss such a claim, the party claiming negligence must first be given the opportunity to bear the burden of establishing negligence by introducing either direct or circumstantial evidence. Negligence has to be established by the party claiming negligence on the part of the other party. This follows a normal evidentiary rule that can be summed up as follows: he who asserts must prove. I hope you found this information valuable. If you want more information, then please read my blog of the same name called "If a Judge Cannot Determine Negligence in an MVA Between Two Vehicles, Are Both Drivers Equally at Fault?" In my blog, I take a deep dive into the legal implications following a situation where in a collision between two drivers, the evidence shows that one or both drivers are negligent, but the trial judge is unable to distinguish between them, as well as provide links to other blogs and vlogs, such as Causation, the but-for and material contribution test, which provide additional information you will find helpful. My website is your one-stop source for answers to all of your legal questions concerning tort law, personal injury law, and catastrophic impairment law. If you want to book a free consultation with me, then please visit my webpage at RudderLawGroup.ca and click on the free consultation button at the top of the page. Let us be your rudder that steers your legal ship in the right direction. Please subscribe to my YouTube channel and click the like button if you found the content valuable. There you'll also find other vlogs of valuable content on tort law, personal injury law, and catastrophic impairment law. Thank you, and I'll see you soon in episode 7 of Personal Injury Lawyer Tips, where I'll bring you more useful legal information.